Hello, everyone. This is Advocate Lucinda, your empowerment lawyer. Today, we're going to talk about suing joint employers. And in particular, I want to talk about the temporary staffing agencies and the companies they send their employees to. Did you know that staffing agencies discriminate? And the companies that they send their employees to discriminate based on a person's race, sex, religion, disability, age, all of those protections provided by EEOC. And sometimes the staffing agencies, although they take the applications, they don't send their applicants to employees based on discrimination. I know this is harsh, but it's true. And companies that they send employees to discriminate against the employees. Sometimes the staffing agency is not aware of it. But here's the point. Both discriminate. And so when an employee is discriminated, they can sue both or one or the other. What I find is that with regards to the companies that receive these employees, a lot of times they take the position that because I am not the employer of the employee, I can get away with discrimination. Well, that's not true. And of course, the first thing you want to do as an employee is determine if you've been discriminated against. And then who's liable? We're going to look at some actions that demonstrate discrimination. So you want to watch this. So let's get started. So let's look closely at this joint employer doctrine. According to the EEOC, a temporary staffing agency and the client company where they place workers can be considered joint employers if both entities exert significant control over the employee's work, meaning they can both be held liable for discrimination or other employment violations against the temporary worker. So let's look at some EEOC rules. According to EEOC, a temporary employment agency is covered by their laws if the agency regularly refers employees to employers or the individual companies that they contract with. This is true even if the employment agency doesn't receive payment for this service, and the agency is covered no matter how many employees it has. EEOC further provides that staffing firm workers are generally covered under the anti-discrimination statutes. This is because they typically qualify as employees of the staffing firm, the client to whom they are assigned, or both. Thus, staffing firms and the clients to whom they assign workers may not discriminate against the workers on the basis of race, color, religion, sex, national origin, age, or disability. The EEOC and the NLRB, or National Labor Relations Board, have standards for determining joint employer status, and both standards consider an employer's control over an employee's term of employment. However, the NLRB's 2023 rule expanded the criteria for joint employer status more than the EEOC's standard. So let's look at some actions that could create the joint employment doctrine. The entity's right to control when, where, and how the worker performs the job. And the entity in this instance is the staffing agency and the company it outsources its employees to. The entity's right to assign additional projects to the worker. Whether the work is performed on the entity's premises. Whether the entity provides the tools, material, and equipment to perform the job. The duration of the relationship between the entity and the worker. Whether the entity controls the worker's schedule. Whether the entity can discharge the worker. To further help me explain this doctrine, we're going to look at a federal employment case and a non-federal employment case. Interestingly, according to EEOC with regards to these disputes, federal agencies often conclude that an individual is not an employee based solely on the fact that the individual performs work pursuant to a contract between the federal government and an outside organization, and the outside organization, not the federal government, controls the pay and benefits of that individual. Well, that's not true, as we'll see in the first case. The case is Laquita H., complainant, versus Pete Buttigieg, Secretary, Department of Transportation, Federal Motor Carriers Safety Administration Agency. And this is a 2019 case. Complainant was employed by staffing firm agency. She served the agency as an administrative assistant at the agency's Deputy Administrator's Office in Washington, D.C. On May 25, 2022, complainant filed an EEO complaint as amended, alleging that the agency discriminated against her based on her age, and in reprisal for prior protected EEO activity under Title VII and the ADA when she was repeatedly denied opportunities to compete for employment. More specifically, she alleged, 1, that on or about July 16, 2019, she learned a younger employee was permanently hired over her without an announcement of the available position. 2, that on or about August 13, 2019, she was terminated from her contract position. And 3, that on November 15, 2019, her job offer for the position of executive assistant at another agency was rescinded. The agency dismissed the complainant's entire complaint for failure to state a claim, concluding that she was not an agency employee. On appeal, the EEOC found that the record revealed, among many factors, that the agency gave complainant at least some of her assignments, that the complainant worked on site at the agency and used agency equipment while employed by 5 different staffing firms for nearly 17 years. After considering the circumstances of the complainant's relationship with agency, the EEOC concluded that the agency exercised sufficient control over the complainant to qualify as a joint employer. Accordingly, the EEOC reversed the final agency decision and remanded the case to the agency, and that would be EEO, for further proceeding. The next case is a non-federal employment case. Felder versus United States Tennis Association, and it's a 2022 case. The United States Security Association, USTA, contracts with security firms that hire and assign their security guards to work at various USTA events. USTA contracted with AJ Security Firm. Felder, the complainant, was employed with AJ Security Firm as a security guard. AJ Firm assigned Felder to work at USTA during one of its events. Felder sued USTA for discrimination under Title VII and 42 U.S.C. 1981 and retaliation. The defendants filed a motion to dismiss, asserting that Felder failed to establish that USTA was his joint employer. The district court dismissed Felder's lawsuit. Felder appealed. Upon review, the appellate court found that Felder had sufficiently established that he could demonstrate through an amended complaint that USTA was his joint employer, at least to survive defendant's motion to dismiss on his retaliation claim. The appellate court vacated the district court's dismissal of Felder's retaliation claim and remanded with instructions that he, Felder, be permitted to amend his complaint as to his retaliation claim. And please read the case. It gives you greater insight on the joint employment doctrine. So as we can see here, control is a factor for the courts to determine employer liability. I trust this has been helpful to you. And as always, I'm Advocate Lucinda, your empowerment lawyer. And we'll see you next time. Take care.